Mr. Sorrell.
May it please the court, I appear for the appellants, together with my learned friends Mr. Hibbert, Mr. Smiley and Mr. Archer. My learned friend Ms. Delaney KC appears for the respondent, together with Mr. Duffy KC and Mr. Goldfarb. My lords, this is the hearing of an appeal from an order made by Mr. Nicholas Tonsell, sitting as a Deputy Judge of the High Court on 21st of January 2025, with the permission of Lord Justice Holgate, granted on 23rd of April 2025. My lords, there are two distinct issues before the court, referred to below as issue 1 and issue 3. The former relates to contractual interpretation, the latter to statutory interpretation. And as you will be aware, they were decided as preliminary issues in these proceedings in the first trial of these proceedings. And you will be aware that there was a second issue, which was resolved by consent shortly prior to the first instance hearing, relating to the existence and nature of an implied term. My lords, before I proceed to deal with the substance, can I deal with housekeeping, if I may?
Yes.
And just first on bundles, my lords should have a core bundle and a supplemental bundle.
Yes.
Can I just check that they've been updated as they should have been? Core bundle should now include a tab 16, which is the appellant's addendum note.
Mine does.
Which has gone in by agreement. And the supplemental bundle should go up to and including 17. You've been provided with limited extracts of witness statements that were available before the first instance court.
Again, mine does.
17.
And then authorities, my lords, you should have an original bundle which was comprised of 2 volumes, and then a supplemental bundle was hopefully delivered at the end of last week, containing 2 items from me and 2 items from my learned friend.
And again, those have reached me. I think they've reached all of us.
And then finally, skeleton arguments for the appeal. You have the skeleton from each side, which are at the back of the core bundle, 14 and 15, and then you have my addendum note, which is now at tab 16.
Yes.
My lords, timetable, and we're grateful for the exchanges we've had with the court in relation to the timetable. There's quite a lot to cover. I expect that I will probably take the most of today. My learned friends kindly agreed not to hold me to the 3:15. I recognise if I take longer today, then I may have less time in reply. We're going to try and be flexible and just make sure we can get through the material, and with everyone, a bit of flexibility from everyone, that should be achievable.
My impression at the moment is the contractual point, whichever way it ends up going, is essentially quite a short point.
Yes, I'm not going to commit to that because I want to show you some of the background briefly, because to understand, for the court to decide whether a term has been breached, you need to understand what's been done, as well as what the term provides for. But I recognise that there may come a point where my lords tell me, I think we've got your case.
Yes, I see. Okay.
If we proceed, and I will take it as at pace, and no doubt if I'm going too fast, you'll let me know. If I'm going too slowly, you'll also let me know.
Yep.
Now, one final preliminary point that applies to both issues, which is that I repeat with respect the point made in the appellant's skeleton. And for reference, it's paragraph 10 of the skeleton at page 214 of the core bundle, namely that the issues before the court, the nature of the issues before the court, and the fact that the first instance judge was not making factual findings based on oral evidence, nor was he exercising any kind of case management discretion, mean that this court is as well placed as the first instance judge was to reach its own views. And for background, the first instance trial took place without any disclosure having been given in the conventional way, nor any witness statements. All there was by way of witness evidence was a statement from each side's solicitor that was submitted for what was originally an application for a group litigation order, which was then withdrawn because the parties decided to proceed with this preliminary issues approach. Now, in light of that, while I will obviously try to draw your attention to where I see the judge went wrong, I'm going to focus on what the right answer is and why, rather than some micro-passing of the first instance judgment, which one sometimes sees where it's a case management decision that's being challenged. My lords, against that background, I propose to turn to issue 1, the contractual interpretation issue. And the question for the court is, has TSB breached the express terms of the claimant's mortgage contracts by charging the claimants interest rates based on what TSB describes as the Whistletree SVR and not the TSB SVR or TSB HVR? I will address you on this as follows, if it is acceptable to the court. Firstly, an outline of the key facts, and I do appreciate you're going to want to focus on the terms of the clauses, but I want to show you the context in which this arises, why we are here, and what is it that's been done that we say is a breach. So facts briefly first. Secondly, I will draw attention to the legal principles on which I place particular emphasis. That will be brief. I don't propose to address you on all the history of contractual interpretation for obvious reasons. Thirdly, and the biggest part of my submissions will be looking at the documents. Starting with the offer letters. Why? Because the conditions expressly say that the offer letters prevail in the event of conflict. The judge dismissed the offer letters altogether. He was wrong to do so when the terms of the conditions say the offer letters prevail. Then the unsecured loan documentation. The unsecured loan documents are in the bundle. It's a package that's being sold to the together claimants. You have to look at these documents as a package. And then I'll look at the conditions. And I'll make my submissions as I do so on how this should all work. And I will seek to present to the court a coherent, logical, and commercial thesis for how the pricing in these arrangements is intended to achieve a fair and appropriate outcome. And that's what was agreed. Section 1, key facts. The claimants are individuals who are all former mortgage borrowers of Northern Rock. Their mortgages have since been transferred to TSB. Little known fact, at least to me, until I was instructed in this matter, TSB was a bank originally set up in the 19th century to help people of modest financial circumstances save money, not a new bank to the market. There are 392 claimants in the claim. Many more are subject to a proposed standstill agreement, such that the total number of people who stand to be affected by this appeal and these proceedings is over 2,000. The reference, and I'll do it this way if I may for things where the court can look at it in its own time, footnote 1 to the appeal skeleton, bundle, page 211. The claimants took out their mortgages roughly in the period 2001 to 2008, with the majority between 2005 and 2007. And that's relevant because it will guide my focus in relation to the conditions. The claimants divide broadly into 2 categories, and I know you'll have got a lot of this already, my lords, but just so we're clear. The together claimants and what are called in the pleadings the core claimants, so I prefer the expression non-together claimants, because actually there are at least as many together claimants as there are non-together. So the non-together claimants, or core claimants, took out the mortgage loan only. The together claimants, who as I say represent more than half, I'm instructed, including the standstill claimants, including that whole body of potential claimants, took out a product which Northern Rock marketed itself as together. You'll have seen that language on the documents. Combined a mortgage loan, a secured mortgage loan, with an unsecured loan of a smaller value. All of the mortgages, all of them, provide for an introductory interest rate, also sometimes referred to in the documents as a special rate or initial rate, for a fixed period of time. Now that introductory rate, my lords, and this will be well familiar to you from usual day-to-day practice, it can either be a fixed rate for that initial 3 or 5 years or 2 years, or it can be a tracker rate, fixed at the level above base. And then on expiry of that initial period of time or special period of time, the interest rate reverts to what the offer letters refer to as Northern Rock's standard variable rate, also referred to in the offer letters as our standard variable rate. Relevant because you'll be aware from the mortgage conditions that our becomes TSB generally, where the context so requires, post-transfer, where the context so requires. For the together claimants, the interest rate on the unsecured loan is the same as the rate on the mortgage, unless you redeem the mortgage, at which point the rate of the unsecured loan is provided to increase significantly. I'll show you that. Now, as you will be aware, Northern Rock was a bank which was subject to a liquidity crisis, which really took expression at the end of 2007, early 2008. As a result of that unprecedented crisis, it collapsed effectively in colloquial terms, and it was nationalised on the 22nd of February 2008, with the shares in Northern Rock PLC being transferred to the Treasury solicitor as Treasury nominee. My lords, the history of what happens next is set out more fully in the amended particulars of claim, purely for reference. Core bundle, because I appreciate you may want to traverse some of this in the judgment, I don't propose to traverse the history here, but for reference, it's amended particulars of claim, core bundle tab 9, see paragraphs 2 to 6, and you also have the witness statement of Mr. Parker, the claimant solicitor, and you'll find the extract at tab 16 of the supplemental bundle. I should have said the amended particulars are in the core bundle, the witness statements in the supplemental bundle, tab 16, paragraphs 9 to 15 being the most relevant. And you can also see further on this in the reply pleading, core bundle, tab 11, page 180, paragraph 6. The summary, though, for present purposes, is that the intention was therefore to be an orderly disposal of Northern Rock's assets. They're divided in various ways. And the existing mortgage book of Northern Rock is split up. And those mortgage loans to which my clients were party were transferred to TSB. TSB did not take on the whole book. That transfer takes effect in December 2015. The claimants are notified about it on the 18th of July 2016. Nothing turns on that gap for today's purposes. TSB has rebranded this group of mortgages that it has acquired from Northern Rock under the brand Whistletree. It's merely a trading name. TSB Bank PLC is the actual counterparty under the loans. A number of additional matters to which I want to refer. First, my lords, I mentioned that these mortgage loans have an initial introductory rate, typically for a few years, reverting to Northern Rock's or our standard variable rate. First point on the judgment now. The judge in his judgment described this in paragraph 2 as a catch. Now, I don't want to labour this too much, but he seemed to take the view that this was a case of a bad bargain on the claimant's part. And you see in the next paragraph of his judgment, he says, the claimants were told all about this. It was drawn to their attention, this catch, that you move on to an SVR. It stresses that the claimants were well aware of this feature. With respect, it's a very odd way to describe this arrangement, because as the court will be aware, I hesitate to suggest, it was squarely consistent with usual market practice in the UK mortgage market at the time. Nothing unusual about it. And my clients have not knowingly gone into a transaction which has a catch. And my lord, Mr. Parker in his witness statement explains, and we can look at this very quickly, supplemental bundle 16. Please. He explains at page 214. So supplemental bundle tab 16, page 214, paragraph 16, please. He explains the common feature of the claimant's mortgage. He says, at the end of that introductory period, the interest payable would be a reversion rate. The reversion rate and so on. And he says it was noted in the Mortgages Market Study interim report published by the FCA that the mortgage market is one in which consumers take out a mortgage with a short-term introductory rate, which typically reverts to a higher interest rate, creates an incentive to switch to a new deal. I would add, so we've got an FCA report that quoted there that confirms the position, and indeed, in the witness statement of the respondent, TSB, served by their solicitor, it is agreed that this is a standard feature in the UK mortgage market. And for your reference, it is the witness statement of Ms. Lamb in the same bundle, supplemental bundle, tab 17, page 226, paragraphs 11 to 12. So it is an odd thing one sees. It's also wrong what the judge says there for another reason, which is that the usual practice in the market prior to the credit crunch, certainly, and I would suggest also the usual practice now, is for borrowers to seek to remortgage when you get to the end of your introductory rate. And you can see, I showed you the reference in the FCA report, there being an incentive to switch to a new deal. I would again diffidently suggest that we may all be familiar with this from our own financial circumstances, but you don't have to rely on that because it is all set out in Mr. Parker's witness statement. In the same document we just looked at, paragraphs 17 to 20 explain at some length that it wasn't just my client's expectation, objectively interpreted, objectively assessed, because I appreciate that's the test, but it was Northern Rock's expectations. And you can see all the quotes, for example, in the quote in 17, where Northern Rock repeatedly refer in the material, in its marketing material and other material to which its clients would have seen, that you can transfer to a new mortgage deal when your introductory rate expires.
The catch, he's referenced the catch, which I agree was quite a striking phrase, was the catch to the fact that under this deal, the borrowers were able to borrow more than the assessed value. Some borrowers were able to borrow more than the assessed value of the property that was mortgaged.
That's not, I mean, maybe, my lord, I have misread the judgment there. My reading of what the judge had said.
We were not going to pass the judgment, as you said.
My reading was that it's the moving on to an SVR.
The last sentence of paragraph 1 is what comes before the catch.
Yes, maybe. My bundle has just fallen apart, so I can't look at it. Forgive me, my age.
That's your case.
Well, he says, the catch, I recognise that he does talk about the attractive packages.
The striking,
But
I read it as being the last sentence of paragraph 1 is what's.
Yes, I see.
That is what he's talking about.
I see that he's referring to the together package, but the catch isn't that you can borrow more. The catch is that you revert to an SVR after a short introductory rate. That's, in my submission, that's the negative. But actually, that's my point is that's absolutely standard in the mortgage market. And indeed was agreed by the parties in those extracts I've referred to have been a standard feature of the mortgage market, and indeed described as so effectively by the FCA. And as to the expectation of remortgaging, that was pleaded, the expectation, so this is the second point. The judge was also wrong because he overlooked the expectation that you'll be able to remortgage rather than end up in this so-called catch situation. It was pleaded at paragraph 25 of the particulars of claim. TSB, for their part, say, well, hang on, there's no guarantee that you can remortgage and you're taking the risk, and they rely on contractual language that says there's no guarantee. I accept there's no guarantee, and we've accepted in the pleading, in reply, that there's no guarantee. We say it's not a guarantee, it's an expectation. That's paragraph 14 of the reply, core bundle 1, page 184. And the response on the expectation from TSB is they say they accept, and they put it this way, that it was not unusual for borrowers in the position of my clients to seek to remortgage. And you will see that for reference at defense, which is core bundle tab 10, page 152. And it's the pleading at 28.3 sub A. it is admitted that it is and was at all material times not unusual for residential mortgages under a mortgage contract with a discounted fixed rate period followed by a reversion to a standard variable rate to seek to transfer to a different product with the same lender with a new fixed rate, and or seek to remortgage with another lender at the expiry of the fixed rate period. If you will indulge me in a lighter moment, it's what I thought of as the Tom Jones defence. It's not unusual for you to plenty more dad jokes in the locker, my lords. 10 years of practice. They also say, though, in fairness to them, they say that it's not unusual for residential mortgages to choose not to transfer to a different product. Well, with respect, and I make this submission purely from first principles, in my submission it's a very odd suggestion that if the SVR is going to cost you more, which in normal market conditions it invariably will, and if you are able to move, then you're likely to do so.
So you're submitting that inertia is never a factor in this market.
No, my lord, but I'm just putting into the appropriate context the way in which these terms are designed to operate. Of course, there will be parties, and it's in different markets. Websites like Compare the Market, etc., are seeking to engage with any possible inertia that might be residual. There will be people who move of their own volition, and then there will be people who are prompted to do so, and then there will be people who don't do so at all.
Was Compare the Market in existence at that time?
No, I'm not seeking to make some forensic evidential point of that nature, my lord. I'm just trying to place this into perspective and the judge's approach into perspective. And I can't make submissions on that. It's not in evidence.
I mean, I was going to say, is there any? We've not got to the stage of there being evidence about all this. So presumably someone will at some point will produce evidence to show what proportion of mortgages transfer and what don't.
I appreciate that, and that's why I seek to place myself on what is pleaded and what is admitted. And I don't invite the court to make broad findings of fact, which it can't make. There may be findings you're able to make simply by taking judicial notice of matters, including that the FCA mortgage market, for example, the FCA report indicates that these were standard sort of arrangements where you revert to an SVR. But in fact, that's a point that's agreed between the parties anyway. My lord, what then happens, my lords, returning to the facts, is we have the financial crisis, we have changes to the affordability regime, and we have this situation where, as you know, my clients say they're unable to move. And they're not assisted here in this case by the manner in which TSB approached their situation. And while we're in the defence, we can pick it up at 29.6, page 155 of the pleadings of this core bundle. And at 29.6 little b, you can see that post-transfer, TSB admit, and engaging with my Lord Justice Arnold, Lord Justice Baker's comments, I'm focusing on matters that are admitted or of which the court can take judicial notice. It's admitted that TSB made available to Whistletree customers product transfers on different terms to the product transfers made available to TSB's other customers. Further admitted that until 2020, the interest rates available on product transfers were higher than those available to other customers. And so you have this situation that my clients complain. And returning then to the core issue on issue one, what happens in those circumstances is that my clients are charged by TSB a rate that is a kind of reversionary rate of sorts, which TSB maintains is the reversionary rate under the applicable contractual documentation, but which we maintain it was not in fact entitled to charge because it is neither Northern Rock's standard variable rate nor TSB's. And I would add that no one's suggesting that there is a Northern Rock SVR, and as we say in the skeleton, forgive me, I have a reference to it somewhere, but the business that was Northern Rock has radically changed and been carved up in various ways.
Can I just understand that? It's agreed that at the date of the transfer of the mortgages to TSB, there was a rate applicable to the loans.
My clients were being charged an interest rate.
And that was an interest rate set by the government entity that had taken over Northern Rock.
It was technically set by Northern Rock because it was the same legal entity. And it was Northern Rock's, it was described as Northern Rock's standard variable rate.
And just to understand the context a bit more, you mentioned that TSB didn't get the whole of the loan book. Did it at that stage get the whole of what was left?
I don't think there is evidence as to the sequencing of the parceling out of these different parts or sub-parts of the portfolio.
Was it divided between a number of them?
Yes, that's my understanding. There is evidence about this in Mr. Parker's witness statement and Ms. Lamb's witness statement, but I mean, crudely, and I don't have that evidence immediately at my fingertips. I do have notes somewhere about exactly how this broke down, but the short point is that TSB took a proportion of the loans that had been made.
And just still to understand the context, which may turn on the sequencing point, do we understand whether Northern Rock continued to have rates set after the transfer?
I don't think you have any evidence on that. I've just been kindly assisted with the reference to the skeleton I was looking for, which came later in my own notes. It's footnote 46, and it was the paragraph in the skeleton in which that is found. As I understand it, there is a legal entity which has the same company number as the Northern Rock entity originally did.
Meaning there is still such an entity?
Meaning there is still such an entity. It's called something else, and it is the point we make in our footnote, which I don't understand to be disputed, is that as a business, as a commercial entity, it is a completely different beast.
Landmark mortgages.
Exactly. Yes, that's it. So, as I understand it, no one's suggesting that Northern Rock, the business, continues to operate in the form that it did.
But just to understand, up to the transfer to TSB, it's accepted, is it, that the Northern Rock entity, even though presumably no longer carrying on trade in this way that it did, was able to set its own standard rate and did?
I think that's right. I might just want to just check that no one behind me disagrees. That's my understanding of the position. Yes. I'm assisted. It's paragraph 22 of Mr. Parker's witness statement explained, or paragraph page 217 of the supplementary bundle.
Sorry, page number.
Page 217 of the supplementary bundle. Explains that there is explains that the move across to Landmark or the renaming took place after the transfer of this particular sub-book to TSB.
I don't know if any of this will ultimately matter, but just to understand, even though Northern Rock had ceased to carry on business in the conventional sense a lot earlier, it appears to have been able to, and in fact to have done so, fix a mortgage rate up to the 2016.
And we'll see, and we'll see how it did that. Now, it may be that my clients might say, well, there were things that Northern Rock did in that context that were not permissible in a different way. I reserve my client's rights entirely on that, but I'm going to show you now what happened to that rate.
And just pursuing it a moment more, then the legal entity is renamed, but presumably, judging from this, it would still have had mortgage customers.
There was a residual book.
So did that continue to set mortgage rates? I mean, why did the transfer to TSB mean that a rate set before was fine, but a rate set afterwards by the same legal entity wasn't?
Well, I don't think TSB are suggesting, just so we're clear together, I don't think they are suggesting that what they did, or indeed what they were entitled to do, was to follow such rate as may have been set by this effectively Northern Rock ghost entity that picks up the pieces. I appreciate same company number, I appreciate that. But I don't think TSB are saying that that's what they did, or indeed that that's what they were entitled to do. They say that what they did, and this is not my characterization, but it's intended to be a fair characterization of my learned friend's position, is that they took the last standard variable rate set by Northern Rock prior to transfer, and then just varied that up and down with base rate.
And I follow that. So on that logic, and I'm expressing absolutely no view as to whether it's right or not, as and when any element of the book is transferred to someone else, regardless of whether Northern Rock is continuing to trade, presumably, the transferee can either opt to go onto its own standard variable rate, or it can vary up and down the pre-existing rate.
That's TSB's case.
But is no longer on TSB's case bound by whatever may be happening to Northern Rock's own rate.
I think that's their case. Our case, as you know, is that TSB are not entitled to just adopt what was the Northern Rock rate and vary that up and down. That's not what the contracts provide for. What the contracts provide for is, in shorthand, for the borrowers to pay the relevant lender's standard variable rate, the standard variable rate of the lender to which they are indebted. Now, yes, we recognise.
Can I be clear? Does that mean that you say that they should have followed what I, for convenience, call the landmark rate?
No. When you move to TSB.
So sorry, let me be clear before you elaborate. So it is not your case that even though the corporate entity remains the same under a different name, and even though it's still setting SVRs, your clients say, no, that's not the rate applicable to us.
No, that is, you're quite right with respect, my lord, in saying that is not my case. Not the pleaded case, not the case of the claimants below, not the case of the claimants now. The case of the claimants is that when you move to the new lender, what the contract provides for, subject to one derogation, which is a practical one, is that you should be paying the rate of the lender to whom you are now indebted. Now, the derogation is that we recognise that there may have to be a period of transition. And so it's possible, and you'll have seen the language, we're sort of anticipating the points from later, but so it always goes that way. You'll have seen the language of may, upon which my learned friends place heavy reliance. That is designed to allow that, for that period of migrating borrowers over. But in normal market conditions, you would never expect that particular fixed number to be maintained in perpetuity. So yes, for a period of time, the parties contemplate that the last rate, the last interest rate, the last number set by Northern Rock may endure. But what the parties are envisaging, and it's paragraph 60 of the appeal skeleton, is that in due course, the new lender will apply its standard variable rate. And this really matters because the standard variable rate provides protection to the borrower in the form of market constraints. And I'll show you this.
And I'm taking you completely out of your course, probably unhelpfully, but I'm puzzled by the idea that the new lender couldn't choose to stick with the Northern Rock rate.
I understand that. My understanding of the framework of the arguments which we are debating before you is that no one is suggesting that that was an available approach.
And
in this case.
I follow it may not in practical terms have been available, but on the contractual documentation, I can't see what precluded anybody from sticking with the Northern Rock rate. And I mean, suppose Northern Rock had still been trading in the conventional way, so pre the collapse, and Northern Rock transfers some of its book to somebody else. Well, on the definition of standard variable mortgage rate or whatever it is in the conditions, it looks as though you can stick with the Northern Rock rate or you can move to another rate.
I understand that, and I think the part again. I come in on appeal. My understanding of the parties' shared factual starting point is that that's not a runner, because it simply doesn't exist as a thing. If you'll allow me that sort of language, and so no one is suggesting, and TSB are not suggesting, that it was entitled in the alternative, for example, to follow what is now described as the landmark SVR, because it's just not at all what the contract is contemplating. That post reconstruction, post dividing up, post nationalisation entity. So as I understand, no one is running that case. But I understand the point my lord makes, and I think the reason why it hasn't been explored is because it just doesn't arise.
Can I just, as part of the understanding, part of the context, just check one thing? You told us that only part of the book was transferred, and Mr. Parker deals with this to some extent in his statement. The rest of the book was transferred to other entities at various points, and that included, as I understand it, some other together mortgages. Is that right?
I would need to check that, my lord. My understanding is the same as my lord's. But I'll stand corrected if I'm misspeaking.
I mean, Mr. Parker talks about there
But I
being
think
non-TSB claims.
think that's right.
There are other claims
Yes, there are.
against other
There
That's
are
right,
other,
against other,
prospective claims. Yes.
against other lenders who
Sorry.
took on the book. Is that right?
Yes.
I'm not gone beyond what Mr. Parker
No.
says.
I think, my lord, I'm sorry for having cut across my lord there. Yes, my understanding is that there are other potential claims against other entities that are effectively successors in title to Northern Rock in respect of other portions.
On the do we know are the claims on the same basis that there's been a failure by the entities to charge their SVRs?
I think they don't.
Going beyond what we know.
I think we're going beyond what we know there. I don't think they're issued, for example.
It's probably my fault for not reading Mr. Parker's
No.
statement thoroughly enough.
No, but when the bundles landed with me, my lords, I was reassured by how thin they were, and then rather disappointed when I realised how complex and dense the in fact the material inside them was. So absolutely right. Can I just show you, because you've been asking what happened to the rates. I just want to show you that. And again, I appreciate we're going to construe the contract at the time it was concluded, which the judge did not do repeatedly. But you do need to know what then happened to understand whether that's a breach. You have to compare what was permitted with what was done. So if we can pick up, please, and I'll deal with it, try and deal with this very, very swiftly with your indulgence. It's core bundle, tab 9. Amended particulars of claim. And we can pick it up, please, at page 122. And you'll see there's a heading on the left-hand side, the rates of the SVR. And we identify here the best particulars available to us of what was the Northern Rock. It was renamed for a period NRAM. Northern Rock rates prior to the transfer to TSB, or prior rather to that transfer being declared to us. And the short point, in other words, is you can see that this SVR, this reversionary rate, until the end of 2007, so until and including paragraph 19.4, is 2.09% above Bank of England base. What we then have is the liquidity crisis, and you can see what happens, which is that the reversionary rate departs from base materially and goes up. And you'll remember the nationalisation was on the 22nd of February 2008, and the divergence from base increases and increases and increases. This is a financial entity under significant distress in very unusual and unprecedented market conditions relating to that entity. And by the end, you see we refer at 19.12 to it being 3.79% higher than base. In fact, and I refer here to footnote 2, in fact, and I'll just clarify this, it's a point made by the defence and the defence, but in fact it works in my favour. From 5th of March 2009, it is 4.29% above base. And so you can see that from within just over a year, there is a material divergence from base compared to the previously held position. Unsurprising given the liquidity crisis that afflicted this particular entity. And you can see what TSB then do, and that's paragraph 20. So those rates, by the way, are admitted. So I'm not showing you any facts that are contentious. And you can see what TSB do, which is they take this 4.29% above base, and they run with it, and they simply maintain that divergence by tweaking what they describe as the Whistletree SVR up and down in keeping with Bank of England base rate movements. So they take a rate that bakes in the Northern Rock liquidity crisis, and then roll that out. TSB is not an entity that collapsed. It is not an entity that was nationalised. It is not an entity that suffered the financial distress that Northern Rock suffered. And you can then, to close this story off, see the rate that Northern Rock charged its customers who borrowed in the same period, pre-2010, paragraph 22. I'm sorry, TSB. I expect it's an error I'll make on numerous occasions, is referring to TSB as Northern Rock. But TSB charges its rates to its other customers, what is known as the TSB SVR. This is the rate it applies to a cohort of borrowers otherwise in materially the same position, people who borrowed prior to 2010. And you can see what the rate they apply is.
Sorry, which paragraph is that?
22.
Sorry.
So it treats its own borrowers differently. It applies what it calls the TSB SVR to them. And you will see it is consistently 2% above base.
I mean, I can't see how this matters to the questions we have to decide, but if you're dealing with a residual group who haven't managed to remortgage, one might think the risk is probably higher.
Well, my lord, this is canvassed in the pleadings. TSB suggests that. We dispute that in detail, including referring to the fact that it's not clear whether the figures they rely on are statistically significant and the like. It's traversed, but there's an important point here. And again, you may not be surprised by this either. And by the way, all of the rates I've shown you are admitted. TSB makes a point that it's got one or two other variable rates, which I'll show you. But a point we make, and you'll find this, my lords, at paragraphs 20.3 and 20.4 of the amended reply, for your reference, core bundle, page 186. This book of loans, to which it applies this non-standard rate in my submission, where it applies this 4.29% above base compared to the 2 it charges its own borrowers. And it won't have been lost on the court that the 2% above base that TSB charges its other customers is almost exactly the same as the Northern Rock pre-collapse rate. Market forces in play there. The point we make in the reply is these loans are proving to be very significantly more profitable, pro rata, than Northern Rock, than TSB's other the book very, very significantly. And I will come back to this, but the point of the standard variable rate is to set pricing. And the point of my clients have no bargaining power in this relationship when they enter into the mortgage. It's a really important point, and I'll show you the case law on interpreting contracts with consumers, but we have no bargaining power. Where is the protection? It is
Well, your protection is you can walk.
well, but this is first of all, that you know that my case, my lord, is that I can't. They dispute it, but that is my case. And secondly, it's a closed book, That's admitted. It's in Ms. Lamb's witness statement. Again, I'm taking the points out of turn, so I don't have the reference at my fingertips, but it's admitted that they're not seeking new borrowers for this Whistletree book. And coming back to the terms, because it's absolutely right, we have to look at what the contract says. But it sets pricing and the protection to a borrower, a retail, with no disrespect to my clients, common or garden borrower, Mrs. L from Grimsby, Mr. H from Herne Hill, is that you get the standard variable rate for the lender, which is constrained necessarily by market forces. And instead what we have is a rate being applied by TSB entirely divorced from prevailing market forces. You will see the word prevailing all over the documents. And surprise, surprise, it results in what economists would describe as supernormal profits. On a massively different scale. And that is not what the pricing in these standard form agreements is intended to allow. It's a really important commercial point. Non-negotiable terms. With the man on the Clapham omnibus, the woman on the tram in Manchester. The contract does not say whatever reasonable rate we decide to set, or something similar. It does not put the Braganza term, now agreed, front and centre to do all of the work alongside clause 7.2, which we'll come to. That's not the deal. If you'd have read the contract and you were told, no, they can take the previous rate, vary that up and down, or they can set their own base rate. Northern Rock couldn't do that. Northern Rock wasn't allowed to do anything like that. I'm getting ahead of myself. Right. You've got an agreed statement of facts, my lord, at tab 1 of the supplemental bundle. I want to show you that briefly. It was before the judge at first instance. I'm showing this to you for a particular reason. TSB note and rely upon the fact that they had different so-called SVRs. It's paragraph 14 at page 7. They had a buy-to-let SVR. As I understand it, no one's realistically suggesting that's the relevant rate. These aren't buy-to-let mortgages in that sense, they're residential. We then have the standard variable rate to which I was referring, which is a C, which is the rate that it applies for borrowers who took out their loans before June 2010. That, I say, is the group that is most closely analogous to my group. And as I've shown you, it's not a coincidence that the base rates that were being applied outside of extraordinary market conditions are very closely aligned with the standard variable. And then you get the middle rate, the homeowner variable rate. That applies, it's one that TSB applies to its post-2010 borrowers. And then over the page, you have a helpful table which compares the rates, including the so-called Whistletree rate, which I emphasise, and coming back to my lord's point, it's not Northern Rock's standard variable rate, the Whistletree rate. It can't be. It's not set by Northern Rock, for a start. I mean, a simple point. And secondly, it's not TSB's SVR in any analysis. It's not even the HVR. So that was what I wanted to show you there. And then there is a document that contains some of the contractual clauses pulled out, extracted. It's Core Bundle tab 12. Now, I hesitate to recommend it to you. The documents that we're going to look at contain more terms than are found in that summary. And also, the summary takes them out of order. It looks at the conditions first, then the offer letters. That's the wrong way round. But it's there. Now, if I can, I think that's what I needed to say, my lords, on the fact. We have this Whistletree rate that in no way is a standard rate, in no way is a TSB rate, in no way is our standard variable rate, and it's not Northern Rock's rate either. Just not permitted under the terms.
Was anything said about any of the setting of interest rates in the when TSB entered into this restructure?
Now, my lord really is asking certain questions I don't know the answer to, but should have asked before I
mean,
set foot into court.
Standing right back, I mean, TSB is taking on these assets. Was anything said about what it was and wasn't entitled to do by way of it? Because it wouldn't be surprising if the bank taking on a portion of the loan wanted to be clear about what it wasn't entitled to do.
Is this a good point for me to chip in?
Sorry, I followed a question with a statement. Never helpful.
Well, it's indicative of the area of interest, if I may say so. No disclosure in this case. We have asked for the transfer agreements. They've refused to disclose them at this stage. It's a mystery. But one would have expected them to allocate risk. One would have expected, for example, were you to rule in my client's favour. I'm speaking from first principles as a commercial lawyer with far less experience as a commercial lawyer than anyone in front of me. Well, my lord's practice
majority of those
may well have included, I dare say, ancillary relief and the like. I don't know. Yes. But one would have expected to see indemnities, for example, rights of recovery if TSB doesn't get what it wants, if you're against me. So, and TSB doesn't say it's going to be left high and dry here. So in terms of the answer to my Lord's question,
sorry, can you explain to me how is it relevant to any of the issues we have to decide?
No,
whether or not TSB has a right of indemnity against someone else?
No, I understand, my Lord. I understand entirely the point you're making. I'm just trying to address my Lord's...
Probably leading you astray.
Well, my Lord's question about what was said. Was anything said about what TSB was and wasn't entitled to do? Were there any public statements between Northern Rock and TSB at the time of the transfer about what they were agreeing, about what TSB's understanding was of what its rights were, for example, on transfer?
We don't know.
We don't. Is that an appropriate point for me to address you briefly on the law?
Yeah.
Now, the most recent authoritative statement here is Wood and Capita. For reference, Authorities Volume 1, Tab 6. The key passage is the judgment of law. It's judgment of law charged with whom the other justices agreed, paragraphs 10 to 13. Let me just emphasise some aspects in my own words, but sometimes borrowing from this. It's long been accepted that the exercise is not a literalist one. Paragraph 10. One does not take a granular focus on a particular word in a particular clause. One looks at the contract as a whole, giving more or less weight to different elements in order to reach a view as to the objective meaning. You put yourself in the shoes of the contracting parties, paragraph 10 at the end. Where there are rival constructions, you ask which is more consistent with common sense, paragraph 11, and you test against the commercial consequences of the rival interpretations, paragraph 12. They endorse the approach in Arnold and Britain, which in turn endorse the approach in Rainy Sky. And I move on now. Lord Newberger was a member of the Constitution in both Arnold and Britain and Wood and Capita. It's relevant for reasons I'll come on to. He agreed with Lord Hodge's judgment in Wood and Capita. That was the only judgment given. He gave the leading judgment of the majority in Arnold and Britain. Lord Sumption, Lord Hughes and Lord Hodge agreeing with him, Lord Hodge adding a short judgment of his own. What those cases do not specifically address is the approach the court should take to consumer contracts. These are not negotiated agreements at all. The offer letters and mortgage conditions are on Northern Rock's terms, drafted by them, and my clients have no bargaining power in relation to those terms. And let me now, having introduced where Judge Newberger, if I can describe him as that, because I'm going to show you different cases in which he gave judgments in different capacities. But one then moves forward to see how he sees the approach the law should take to consumer contracts. First as first instance judge, and then as Lord of Appeal in Ordinary, sitting in this court. Let me take these in order, if I may. Was there a...
If he's a Lord of Appeal in Ordinary, he wouldn't be sitting in this.
It's a mystery to me because I'm
Oh, I see,
a
yes, of course.
heathen and I don't understand how this works. Honestly, he was
Sorry,
appointed
carry on.
Lord of Appeal in Ordinary, but he wasn't yet Master of the Rolls.
My recollection is that possibly because he was getting bored, I don't know, from time to time he came down to the Court of Appeal.
Well, we're all very glad that he did because he's instructed us on how we should approach consumer contracts. Because not only did he come down to the Court of Appeal, borrowing my Lord's wording, I would never describe it in that way, but he then gives the judgment of the court. But yes, he wasn't yet Master of the Rolls. There was a gap when he
comes out of this court, he's sitting as a Lord Justice of Appeal, he's not sitting as a Lord of Appeal in Ordinary.
well,
Sorry.
He was at any rate such a lord.
he had been appointed, but he's sitting in the Court of Appeal. I'm not trying to put a fast one, my lord.
I've wasted another minute, I'm sorry.
They're very precious, my minutes, my lord. Joint Supplemental Authorities bundle, please. Tab 1. I'm going to take these authorities quickly, and no doubt the court will read them carefully next
Can't
time.
we assist it by a first instance authority given the subsequent Supreme Court authority?
I understand.
Binding with?
I understand, my lord. It's a question that it's often thrown back at me in this court. I'm just trying to trace the history. The point being, it's not a one-off, what this judge said when he said it in the Court of Appeal. Perhaps I just give
If
you
he
the...
was repeating himself, then surely we can just refer to his latest statement.
I understand. Perhaps I just give you the reference then. But actually, there is one other point I want to show you here. If my Lord Justice Arnold will just indulge me this moment, and I'm sure by the end of the day his indulgence will have expired for sure with me, but if you could just please bear with me. It's absolutely a first instance judgment. Insurance case, transfer of insurance policies from an insurer in liquidation over. And actually not dissimilar in that sense to this case, but in the insurance rather than the banking context. He has to resolve a number of issues. And in the context of issue 3, he comments on this. I would add, if I may, that there's a lot of sidelining in this report. Most of it is not ours, it's only the blue sidelining you need to be concerned with. And we can pick it up at page 9 in the bottom right-hand corner, page 649 of the report. And he says this, he's explaining why he finds in favour of the policyholder. Fourthly, I consider that Mr. Tamlin is justified in relying on the contra preferentum rule. And he quotes the Privy Council. And he explains, as that observation is framed, the contra preferentum rule, if standing purely on its own, is often pretty weak, but is some force when part of the overall picture. And then he says this, that is particularly so in the case of an insurance contract, where the insurer is a large organisation with knowledge of the market and financial ability to employ and obtain the best legal and other advice, whereas the policyholder will always be a small individual with very limited funds and knowledge. The same applies here. He goes on to consider the rule in the unfair terms in consumer contracts regulations, which also apply here. if there is doubt about the meaning of a written term, the interpretation which is most favourable to the consumer shall prevail. That is a broad word, doubt. And the judge rightly says one must be careful of double counting. And it may well be that the provision effectively replaces contra preferentum. But they do provide some assistance. So that's what he says there. And then I would add for completeness, so you have it, my lords, the regulation to which he refers, 7.1, that's 7.2. 7.1, for reference, authorities, volume 2, tab 23, page 358. 7.1 requires the consumer contract to be expressed in plain, intelligible language.
Sorry, so I get a sticker on it. Which page was it again?
Page 358 of volume 2. So there was I'm reminded by going through my submissions in answer to my Lord Justice Arnold's observation about it being, it's the way that Mr. Justice Newberger, as he was then, refers to the unfair terms regulations, on which I also place emphasis. It's a convenient place to see that. Now I appreciate that, as some of the authorities say, you don't strain to find an ambiguity, but the point is it's a broader principle than that. It's not a doctrine of last resort, as has sometimes been said. In a case like this, it's an important principle where you're dealing with the standard terms of a very substantial business, which are non-negotiable. And it wasn't treated as a doctrine of last resort by Mr. Justice Newberger as he was then, or, as we now go on to, by Lord Newberger in the next case, which is behind tab 2.
Of the supplementary.
Of the supplementary volume. Foxton's, it's a case about the correct interpretation of the standard terms of the well-known estate agency. Lord Newberger decides the case in favour of the consumer. And again, I won't take you through all of the ins and outs of the decision, but we can pick it up at page, forgive me, my reference is wrong. At page 15 in the bottom right-hand corner. Well, if we turn back one page, please. Sorry. He says at page 14 in the bottom right-hand corner of page 25 of the report, next to the letter J on the right-hand side, right-hand column, you'll see paragraph 23. And he says both interpretations are perfectly defensible as a matter of pure language. You'll see what he says there. And then he lists his reasons for preferring the client's or consumer's interpretation. And I draw your particular attention here, please, to what is overleaf on the left-hand column at letter F. It's paragraph 31. Fifth, this case is concerned with Foxton's standard terms. Accordingly, one should leave in favour of a construction that favours its client, particularly in the field of domestic agency contracts where the agent is an expert, professionally qualified, normally legally advised, so on and so forth. It's exactly true here. So, whether sitting as Lord Justice, Lord of Appeal in Alderley, it's the judgment of the Court of Appeal. And it's not a doctrine of last resort in cases like this. It is something you bring in to assist you in reaching the right answer as part of the overall contractual construction exercise. And it is either under the common law or on the basis of the regulations. I accept you don't double count. And I would add two things in response to authorities that my learned friends rely on. First, they say, don't worry about the offer letters, because you've got to look at the conditions and interpret them in the same way across the board. I think they rely on a case called AIB for that. Not so where the offer letters are part of the contract and the conditions expressly provide that in the event of conflict, the offer letters prevail. It's condition 22, I'll show it to you. That's that point. And also we have here an unsecured loan agreement, and it's a package in the case law on treating contracts entered into as a package is well established. And it's not in the authorities bundle, but I mean, everyone has their own case, but Lord Mance in, forgive me, where was it? I'll have to come back to it, but there's a Lord Mance statement to the effect that where the transactions are linked, the law should strive to interpret them consistently with one another. I'll come back to it, but it's not a surprising principle. The second case they refer to is the Deutsche Bank case, I think brought by the state of Denmark or the state of the Netherlands, I forget, which is about the construction of the ISDA master agreement in derivatives transactions. And it's a completely different context. It's a heavily negotiated form of draft by all industry participants. And it's, I mean, and also you're dealing with very sophisticated parties, as evidenced by that case between a state and Deutsche Bank. It's not the right measure or approach. These are individuals of modest resources from ordinary walks of life. And I include myself in that category. So it's not intended to be deprecating in any way. My clients. I'm reminded of the case of the Lord Mance decision I had in mind, Durham against BAI. And so purely so you have it, the reference 2012, 1, weekly law reports, 8, 6, 7, para 69. It's not intended to be a controversial proposition about reading documents that form part of the package together. One last point on the law, if I may. It's the principle from Chartbrook. Now, that's in the interest of economy, not in the bundle, but the key passage is in the judgment. We can pick it up, please, in the core bundle. We can put the authorities bundles away. Pick it up in the core bundle, tab 5. Page, tab 5, page 77.
Just to be unhelpful, I've got printed out a double-sided version which doesn't have the bundle numbers. So if you could give paragraph
Paragraph
numbers.
99, my lord.
Thank you very much.
The judge quotes Lord Hoffman in Chartbrook. The contract does not use algebraic symbols. I'll come back to that. It uses labels, they're seldom arbitrary. And you'll see what's said there. And it's not just the label point about standard variable rate I rely on, it's the substance of that word, which is the point Lord Hoffman was making. Chartbrook was a case where the court rejected a literalist application of a definition. And the court took the view that it did not make commercial sense if interpreted in accordance with the ordinary rules of syntax. The last point, my lords, authorities, volume 2, please, where we're talking about the meaning of the word standard variable rate. Before I turn to the documents, it's tab 35, right at the back of the bundle. And it's the second page, please. What you have here is the FCA's product sales data glossary. It defines terms that it uses, and it is effectively for the purposes of gathering data about how financial institutions sell products.
Can you help me? What is the date of this document?
I will have to double check, my lord. I will double check. There is no date in the index, and I will find out as best we can what the date is. I have looked at it. I'm sorry.
You're relying on this in part of your submissions on the law. And how is this law?
I'm using it, if I may, as a bridge to the contractual documents. So I appreciate it's not law.
But it's not referred to in the contractual documents, is it?
Well, we have an expression used, repeatedly used, which is standard variable rate. And I appreciate there's a definition of that, and we will look
Sorry,
at it.
before we look at what the document document says, we have to understand the basis upon which we are looking at it. At the moment, this seems to be a post-dated document. It seems to be a document that's not referred to in the contract. It seems to be some kind of statement from a regulator, as opposed to any law stated by a court or parliament. So how does this help?
It's factual, it's relevant to the factual matrix, my lord, and I take your point on the date.
It can't be relevant to the factual matrix if it postdates.
Or we'll check the date. We'll check the date. I take your point. My lord, you have the definition. My lord, for what it's worth, taking on board my Lord Justice Arnold's points, you have the way that the market, at least from the perspective of the regulator and the financial institutions that are subject to its rules.
Just so I understand, what do you say the significance of the definition of SVR is for this case?
It provides relevant context as to how market participants understand the meaning of the word. But I take on board the date point, and we will check the date. Because the factual matrix has to be assessed at the time of contracting. Absolutely acceptable. I just wanted to show that to you for context. And if it falls away because of the date, then it falls away.
I'm still puzzled, and I apologise if I'm being obtuse, and I'm sure it's my fault. Just assume for the moment that the document predates the contract. Okay, so you don't have that. How is it part of the factual matrix? Is there evidence that any consumer entering into the mortgage contracts in question would have seen this document?
Well, in that eventuality, it would have been something that, on my lord's assumption as to timing, it would have been certainly in the contemplation of Northern Rock. Northern Rock would have been well aware.
But why? Why would it be in the contemplation? I mean, it just seems to be some kind of glossary of terms.
My lord, I don't want to dwell on this point and take up unnecessary time on it. I understand my lord's observations entirely. I just put it before you for context. If my lords don't find it helpful, whether because it's the wrong time or for other reasons, I've got other points.
Michael, I just want to understand what weight you say we should put to it.
I say, subject to the date, that it provides context for how market participants would have understood the meaning of the word standard variable rate, as on the financial market participants on the side of financial institutions.
I mean, I still wonder how much it adds, because what it says is pretty unremarkable, really.
I understand that. I think I'll move on, I think, if I may. My lord, I'm conscious I didn't mention this in housekeeping. I should have done. We have a transcriber in court. In my experience, the Court of Appeal takes different views on
the Court of Appeal tends, at least nowadays, I'm afraid, to say transcribers should take their own breaks when they want to and catch up later.
Very well. My lord, next section of my submissions, the contracts and in particular the documents. Now, you have been provided in the supplemental bundle with various examples of offer letters and the general conditions, as well as a couple of examples of the terms of the unsecured loans in the case of the together borrowers. I'm going to focus first on on a set from 2005, partly because it's been agreed that the general conditions from 2001 and 2005 are materially identical, and that this issue should be determined by reference to those conditions. But also partly because, as I understand it, on our side of the cause at least, the single greatest group of claimants, including the standstill claimants, borrowed in that period when the 2005 conditions applied. Well, I mentioned that at the start. And I'm going to start with examples relating with a together claimant, because as I said, they form at least half or more than half of the pool of claimants, including the standstill ones. But I'll try within the constraints of time to show you the variations elsewhere. Allow me, please, to start with the offer letter, given that those terms prevail. I'm then going to look at the unsecured loan, then the conditions. I'm going to show you three versions of the offer letters that are referred to and appended to Statement of Agreed Facts. I'll start, please, with supplemental bundle, tab 10. And it's page 162. It is a contract, it is an offer of loan to Mr. and Mrs. H, dated 25th of August 2005. I appreciate you have looked at this, my lords, but I'll take it relatively quickly. And so the front page you'll be familiar with. There's a recommendation to take legal advice at the top in the usual way. If you look in the bottom left, very bottom left-hand corner, you can see there in small letters, together, 3-year fixed. So that tells us it's a together mortgage, and the introductory rate is a 3-year fixed rate. If you turn over in box 3 or section 3, your mortgage requirements, secured loan amount, second bullet, 152,000 plus fees, purchase price 160,000, repayment method, it's a repayment mortgage, term 35 years, and there's also going to be an unsecured loan of 30,000. That's the together aspect. 3A over the page, Northern Rock's important mortgage requirements. Other conditions, under the heading Other Conditions, please refer to the section headed Northern Rock's additional mortgage requirements for other conditions. I will come back to, I'll show you where that is found. If you turn over again, section 4, top of the page, description of this mortgage. This is a Northern Rock product. You can see the loan amount, the repayment method, the term of the product, and what it's described here as the initial rate payable or special rate, fixed rate. And it says below the little table, the secured mortgage is based on the following interest rate periods: a fixed rate of 5.99% until 1st of October 2008. That's the 3-year fixed, followed by a variable rate guaranteed to be below Northern Rock standard variable rate, which is currently 6.59% for the remainder of the term. Please note that the payments illustrated for this period of the mortgage are based on Northern Rock's standard variable rate. And you will know from what I showed you earlier in the pleadings that the standard variable rate that is referred to there at 6.59 was then just over 2% above Bank of England base. That's what I showed you in the pleadings. This is pre-collapse. It is important that you read section 12. And under paragraph 6, under section 6, you again, bottom bullet, this sets out what the borrower will need to pay: 387 payments at the Northern Rock standard variable rate. On any view, TSB has not been charging that.
Forgive me, where were you just reading from?
I'm sorry, I was at the bottom of 165.
My mistakes, thank you.
No, I'm just conscious of time, but please do interrupt me if it's not clear. So TSB is not charging this. We then have the additional features at 12, page 169. And you will see that the references to Northern Rock standard variable rate are also frequently referred to as our prevailing standard variable rate. And that's relevant because of the definition of our in the conditions. I'll show you all this. Definition of our in the conditions means that where the context requires, that is a reference to TSB. So under additional features at 169, you can see at the bottom of the page a heading unsecured borrowing. And you can see on the unsecured borrowing, bottom of the page, if the secured mortgage is transferred to another Northern Rock product or repaid in full, the rate of interest charged for the unsecured loan will increase to 5% above the current standard variable rate. I emphasize standard, not some bespoke rate that is not the standard rate. Again, what is the protection here? And we turn back to box 4, 165, guaranteed to be below. This is a non-negotiable instrument. Where is the protection for the borrower if you are not to apply your standard rate constrained by market forces, assuming ordinary market conditions? Where is the protection for the borrower if the transferee can set a new SVR? No, they say they haven't done that. They say we've taken the old one and moved it. But that is effectively, it's not the TSB SVR or even one off. It's not the Northern Rock SVR. That doesn't exist anymore.
Can you help me on this? Is there a claim for breach of the guarantee?
It's not pleaded in that way. I use it as an argument that you would be very significantly reducing the value of these words and similar words that one finds in the non-together offer letter. The non-together offer letter is slightly differently worded, but the effect is similar. You will be very significantly diminishing the protection, the quid pro quo, if the transferee can do what TSB has done, which is take a rate that bakes in a crisis and run with it. The point of this provision is that you get the market rate constrained by market forces. And that, it was described as pack protection below. I don't think, it was then referred to, in the judgment at least, as herd immunity. It's not immunity, but there's a protection from being...
Help me understand this point. So you take us to language which on its face appears to be a guarantee. You tell us that there's no claim for breach of the guarantee, but somehow you still seek to rely upon it, and I'm just a little bit struggling with that.
There's a claim for breach of the express terms of the agreement.
But not a claim for breach of the guarantee.
It's not articulated as a claim for breach of guarantee. Because I think that in my submission, if this is a guarantee, it's not the sort of guarantee that one that attracts all of the jurisprudence applicable to guarantees under seal or whatever it may be. It's intended to be ordinary contractual language,
Indeed, yeah.
understandable to the retail borrower, and providing them with a protection. The word guarantee is there to convey comfort and assurance. Now, what is the value of this if you're not going to get the standard rate?
I mean, leave aside how this fits into this case, but it's not just assurance. I mean, that must have been a contractually binding
Absolutely.
obligation,
Absolutely.
wasn't it? How much worth it would have, supposing Northern Rock was still trading normally, I don't know, because presumably you could be 0.001% below
And I
the
think
Northern Rock rate.
And I think that Northern Rock did treat it that way. But the point is, it's the reference to the standard that brings you into the rate that can only be constrained by market forces, because you're going to be treated like everyone else. And the bank cannot be approach that in a discriminatory way, because in ordinary market conditions, with an open book, competition in the market, you are going to be constrained in how you set your SVR.
Can I ask a completely different question about this box? It uses the term Northern Rock Standard capital S, variable capital V, rate capital R, which might or might not alert the reader to the fact that it's a defined term. It depends on the reader's experience of defined terms. But if they were to understand that it's a defined term, would they find the definition anywhere within the letter? Or would they have to look elsewhere?
You have to go to the conditions. And we will go to them. Can I just show you?
And do you accept that whether or not the reader at the time understood this, that's to say the recipient of the offer, whether or not they understood it, it is in fact a defined term defined in the general conditions?
There is a definition of standard variable rate. there is a definition of standard variable rate. That is as far as I will go in answer respectfully.
Right. So I'm left puzzled as to what effect this has. So you accept that there's no definition of the term in this document. You accept there is a definition in the conditions. In which case, why is the definition in the conditions not imported here?
Oh, it absolutely is, but when one has to take the documents together. I'm not seeking to move away from the conditions. The conditions are part of the contract. I'm looking at this document first for two reasons. First of all, it's the first document you're going to read as the borrower. It's the cover document. Second of all, it is part of the terms, part of the contract. And third of all, if there's something in here that clashes with the conditions, this prevails. So it's the natural starting point for the analysis.
Is there anything that clashes?
Well, at the very least, one has to understand that the way the protection is intended to operate. Because yes, on TSB's analysis, you are going to very substantially diminish the value of that contractual bargain if you interpret the clause in the way that they invite the court to do. So yes. Now, can I just show you 12A before we move away from this document? Page 170, Northern Rock's additional mortgage requirements. You'll see it says guaranteed rate bracket basket rate. On expiry of the special rate period, the rate will be set at a rate guaranteed to be below our prevailing standard variable rate set by us, our and us post-transfer. Where the context so requires will be a reference to TSB. Our prevailing standard variable rate. I emphasize prevailing from time to time for existing Northern Rock borrowers. Then that will have to be read as a reference to TSB. And then you can see
why.
Well, post-transfer, that's the only logical way in which to read that clause in my submission.
So where would you put TSB?
In place of Northern Rock there. And you will see that in at least one of the definitions that we're going to come across, Northern Rock is intended, the words Northern Rock are intended to be a reference to a successor. And you can see again in the final sentence under that heading, a reference to our prevailing standard variable rate. I emphasize the word prevailing, not some new rate or some rate that is not your prevailing standard variable rate. And set by us. That has to be TSB. It's all of that is contemplating a pre-existing rate. The other point I want to make here is that these documents understandably refer to Northern Rock. They're contemplating primarily Northern Rock being the lender. And we'll see why that's relevant when we come to the conditions, because some parts of the conditions contemplate Northern Rock as originating lender. But then you have references to transferees, and you have to look at those together. So the contract...
I mean, just to be clear, if you take, say, box 6, 387 payments at the Northern Rock standard variable rate, given that we're dealing with incorporation of the general conditions, and those general conditions contemplate that there could be transfer, that can't tie you to the Northern Rock standard variable rate.
Absolutely.
Is there any relevance to the here, the sentence that begins at any time in box 12A? Or does that have no relevance to this?
Yes, I mean, that's unlimited, isn't it? That must apply to a post-transfer world.
Any time during the rate period, our prevailing SVR may be
No.
lower than the product you have chosen.
I think the rate period,
In some circumstances, we are under no obligation to reduce interest rate being paid.
I'll have to check, but I think the rate periods is likely to be a reference to the special rate or initial rate. And I think that's why the reference to prevailing standard variable rate there is that effectively if you're on a fixed at 3%, it turns out that the SVR at that time is 2%, then Northern Rock will not be obliged to give you the benefit.
So your your proposal then is that the phrase "the rate periods" plural means the special rate period singular, referred to a few lines up, right?
If you will allow me to check that definition, which we may well do together when we come to the conditions in a moment.
So it might be in the conditions.
But that sentence, I think, makes the most sense in that context, because what they're saying is, if the SVR is lower than your fixed rate or tracker rate, we are under no obligation to move you down to the SVR. But I stress the words prevailing in general. And so the protection here is that you get the standard rate of the lender to whom you are indebted, constrained by typical market forces and in line with market. And I stress it would be a very different contract if it said, well, it can revert to a rate set by Northern Rock specific to a particular subgroup, or it could be simply subject to the Braganza type implied term. One must have in mind that a bank naturally is going to seek to read the terms in the way that is most favourable to it. And the sort of outcome that TSB argues for would be a very significant inroad commercially into the bargain that is found here.
The phrase "rate periods" appears in box 4. The secured mortgage is based on the following interest rate periods.
Yes.
Plural.
Yes, my lord, thank you. So it may be, I mean, it's difficult to see how that particular provision can work post-expiry of the initial rate, but I'm not sure I can take that point much further at this stage. So the focus in my submission is to refer to the prevailing rate set by the lender to whom the borrower is indebted. And prevailing and existing cannot be coherent with TSB's interpretation, whereby it's taken and then repeatedly varied and applied to my clients a rate that it's not its prevailing rate and does not apply to any of its existing customers. Can I just show you quickly the offer letter at tab 11? This is a non-together offer letter. For Mr. and Mrs. L, it's page 172. You can see in the bottom left-hand corner, so I'm at tab 11 of the supplemental bundle, Mr. and Mrs. L. Bottom left-hand corner, 5-year flexi fixed. So 5-year initial rate. It's a tracker in that period. Now, and you can see the mortgage requirements in the same box at page 3. And here we can turn straight to box 4. It's slightly different, but broadly similar. Page 175. We see again the secured mortgage is based on the following interest rate periods, the language my Lord or Justice Baker identified. Reference to the Northern Rock standard variable rate. And then that's for 2 years post expiry of special rate, and then you get what's called the loyalty discount rate, where there's a small discount. And again, reference to Northern Rock's standard variable rate. Follow, if your mortgage payments are not up to date, then Northern Rock's standard variable rate will apply. Picking it up, page 182. Hopefully, having looked at the documents together, will at least accelerate some of my learned friends' discussion. It's taking me a bit of time, but I hope it's useful. Under 12A, this reads slightly differently. Once you have had a Northern Rock residential mortgage on your current property for 7 years, we will recognise your loyalty with a discount of our standard variable rate. That can only be a reference to TSB's prevailing or pre-existing rates, because our where the context so requires post-transfer will be a reference to TSB. It has not done that. And you can see again, 4 lines down or 3 lines down, will guarantee a discount of at least 0.25 off of our standard variable rate. I note for completeness that in the penultimate line of this section under loyalty discount, there's another reference to Northern Rock's standard variable rate. Again, the key point is that it should be the standard variable rate, subject to the one derogation I've mentioned, of the lender to whom the borrower is indebted. That is what the borrower is going to come away believing. Then, for completeness, the other version of the letter that is appended to the statement of facts is at tab 7. It's a slightly earlier document in a slightly different form, but the language is very similar. It's for Mrs. B, 14th of April 2004, so I'm in tab 7. It's got the usual language at the start. And then you can see under the at page 145, this is a together tracker mortgage. And here you'll see that the letter looks a bit different. 145, bottom half of the page, rates and rate periods. Maybe the reference to rate periods might be a hangover from this document. We see that a little bit in some of the other language, references to special rate and the like.
Sorry, where are you now?
I'm sorry, my lord, page 145
Sorry.
or in the bottom half. There's a heading in capitals, rates and rate periods. You can see there's a definition indeed at the end of the first paragraph, the special rate period, and one sees that language adopted in the later versions. It's the bottom, it's the penultimate paragraph in this section that's material. On expiry of the special rate period, the rate will be set at a rate guaranteed to be below our prevailing standard variable. And here you see the word mortgage base rate. That doesn't add anything, but I just draw to your attention that the other documents say standard variable rate, this says standard variable mortgage base rate, it's the same thing. Our prevailing, set by us from time to time. It's the same language as I showed you in 12A in the document at tab 10.
That's headed rates and rate periods plural.
It does.
And the same phrase, the same sentence about we're looking at in the first offer letter appears at the top of 146.
Yes. Yes, absolutely, my lord. It's the same.
So effective drafting in the later document.
Now, again, I emphasise prevailing, existing, at our standard variable rate. Strongly points towards my construction. It doesn't contemplate some kind of sui generis or halfway house rate, which is neither the Northern Rock prevailing rate nor the TSB prevailing rate. Does not cohere with that concept that TSB is entitled to take the last number set by Northern Rock and run with it. Not at all. Doesn't apply that approach to any of its existing customers or prevailing, it's not its prevailing rate. Briefly, the unsecured loan agreement, if I may. It is part of the parcel of documents, only obviously arises in the together clients. Tab 8, this is the this is the unsecured loan that goes with the offer letter I just showed you. Now, forgive me, the writing in this is very small. You, my lords, probably have much better eyesight than I do, but I find I have to sort of tab 8. Something I've recently discovered is that if I have my glasses on, I have to hold the document quite far away.
So, a very minor point.
Yes, my lord.
But we see in tab 7, consistently with the other documents, the identity of the customer has been anonymised by
Yes.
redaction, which is perfectly appropriate, I would imagine. But in tab 8, the identity of the individual in question is revealed.
Thank you, my lord. Now, I will avoid referring to this person by name. Now, as I understand it, it's
That's
not,
appropriate.
I'm sorry,
I think that's very appropriate in the circumstances. I'm just puzzled as to
No.
why, given that so much effort has been apparently made to protect identities of individual consumers, in this case, it's not been done.
no, my understanding again is that this particular borrower, that their name has been used in pre-action correspondence and the like, so that I think, as I understand it, there may be less sensitivity in where
That's
she's
fine.
concerned.
I'm
But
grateful for that explanation, but in which case, why redact it at tab 7
Well,
then?
I think you'll find the name and address elsewhere in the documents too.
So that's right. No, it's
Presumed the
maybe it was
individual is a
deliberately
claimant.
set by those behind me as a brain teaser for us all. But I take my lord's point. I will not mention this person by name.
The individual is a claimant, is she?
Yes.
Yep.
Now, I do have magnified, enlarged copies of this document in court if anyone needs them. I can just about cope, but it's.
Looking at me, Mr. Sullivan.
I'm sorry.
Looking at me in that
I'm not. I'm looking away diffidently.
I think I'm sufficiently short-sighted that I can read it.
But yes, exactly. It becomes an advantage. It's particularly the back that's very, very small. It wasn't meant to. It wasn't intended to speak out of turn, my lord. It struck me that I was struggling to look at it. But let me just deal with the document. Financial particulars is the second box under the name of the. Here I will have to take my glasses off. Monthly payments. So you can see the loan amount there, 14,938. The word interest rate. And then under monthly payments, it says, during the initial rate period, the subsequent rate period, and otherwise, those must be the rate periods collectively. Such equal or as nearly equal as possible amount as is calculated by us and notified to you from time to time, as it will result in the then outstanding balance on this agreement, together with interest at the interest rate, all capitalised. You then look, when you're asking what does the interest rate mean, it's below. You'll see about 2/3 of the way down in this box, interest rate is the variable rate stated above. And that's for the introductory period because it's a tracker. And after which date, second half of the sentence, it is guaranteed to be below our standard variable mortgage base rate. And again, you know the words I emphasize. And what is it that a consumer would come away thinking they are going to be paying? And then there's another rate, is the drawdown loan rate under B if you are not or cease to be a borrower. So that's if the mortgage is redeemed, which will be 5% above the standard variable mortgage base rate for existing customers prevailing for from time to time. Again, in my submission, the only way to read that is that post-transfer, when we, us and are going to be generally, where the context so requires references to TSB, TSB's prevailing standard variable base rate as applies to its existing customers. Again, otherwise, you are significantly, very, very significantly eating into the contractual bargain. Now, we turn over to the terms and conditions. Overleaf. I'll just take you through this quickly. Interest. There are definitions at the top under sub 1. Interest means the interest charged at the interest rate. Interest rate is defined, means the applicable interest rate referred to under interest rate in the financial particulars, which is what we were just looking at. And then at the bottom of the definitions, we, us, our, Northern Rock means Northern Rock PLC, including its successors and assigns. Now, you'll see a similar language in the general mortgage conditions, which we'll look at. And it was agreed at first instance, and the judge agreed also, that this sort of language can't be interpreted literally because it can't refer to both, for example, all the time. So it has to be Northern Rock and or TSB as the sense may require, or I would express it as the context may require. And that was uncontentious. So you have to read that definition in a practical and pragmatic way. Now, if we turn down then to the section on interest, which is clause 3 of these terms and conditions, left-hand column, about 2/3 of the way down. We'll see a heading indented 3, interest. We shall charge interest at the interest rate. And then 3.5, a clause that's not dissimilar from what we'll see in the general conditions. We will only increase our standard variable mortgage base rate. Post-transfer, that's got to be a reference to TSB's standard variable mortgage base rate, if one or more of the following applies. And you'll see, for example, at F, a reference to changes in market conditions, banking practice, and so on. I think that's what I wanted to show you.
But why would that help you? I mean, if it's contemplated that you can increase the rate where there's a trend of increasing interest rates.
Because what is, TSB places heavy emphasis on clause 7.2 in the conditions, which is, has some of similar language, but you've got to ask yourself, what is it you are allowed to vary? What is it you are allowed to vary?
But if
It's
the
your own standard variable rate, prevailing, existing, and so on.
and I follow that that's obviously what we're going to come to, but at the point at which you inherit the debt, there is a rate set. And here you're relying on or pointing to clause 3.5. Well, 3.5 of itself allows you to vary by reference to changes in interest rates. So I'm not sure why that would help you.
Varying our, my emphasis is on the word our there. And when you read it together with everything else we've seen here and in the offer letters, prevailing, existing, standard.
Well, the
It
word
can't mean-
standard, I'm just a bit puzzled by this because the word standard appears in clause 3.5, but the words prevailing and existing don't. Does that matter?
I think you have to read the contract as a whole, my lord, and you have to read all of these documents together. That's what the principles and the authorities tell us. And it's relevant because of the approach that TSB takes to clause 7.2, which is no, we can take the last rate set by Northern Rock and vary that. No, you have to ask yourself, what is it you are entitled to vary? And when is that clause engaged? Here, they are varying a rate that is not theirs. It was the last rate set by NRAM, effectively. It's not the TSB standard variable, it's not the Northern Rock, which doesn't exist. And coming then to the judgment, before I move on to the conditions, the judge said, having been shown offer letters and so on, that he would attach no weight at all to the language one finds in these various documents. Paragraph 110, I think he was referring particularly to the offer letters. No weight at all. He was wrong to do so. 4 reasons.
Just show us where he said that.
I'm sorry. 4 bundle, tab 5,
Yes.
paragraph 110, and pull up the page number. I actually have page numbers. 79.
Thank you.
It says at the end, for all these reasons, I will attach no weight. Again, in a sense, whether I land particular criticisms of the judgment, what matters for this court is what's the right answer. But first, you've got the point about in the event of conflict, and it's clause 22 in the 2005 conditions. I'll show it to you in a moment. Second, these contractual documents have to be read together in any event. And the offer letter is if I may use this expression, the leading document. It's the first document, it's the cover document, it's the prevailing document. It's a package, and the unsecured loan also forms part of the contractual picture. All of the principles about reading documents that are executed together as a package come into play here with force. Lord Mance in Durham at paragraph 69. Thirdly, the offer letters and indeed the unsecured loan terms are consistent with one another in their references to our standard variable base rate. And one also repeatedly sees references to prevailing or for existing customers. And the differences between the offer letters don't undermine those core points. And nor would you expect them to, because you wouldn't expect Northern Rock to be seeking to contract on radically different terms by different groups. And the fourth point, and I just advance it for completeness, is that if there were material differences, then the result, at least as a matter of legal analysis and theory, is that you could end up with a different outcome for together claimants and non-together claimants. Now, my position is that we succeed across the board. But if I'm wrong on that, it doesn't follow as a matter of analysis that you just dispose of the points because of the prevailing aspect and the reading the documents together aspect.
Sorry, I'm sorry to interrupt you, but I was just trying to see what it was that the judge said he was attaching no weight to.
Yes.
Am I wrong in misunderstanding that what he's there referring to is what he's talked about in paragraph 100? Because he says that, having quoted the passage from Charlton he took us to earlier, he says he's loath to place too much reliance on the use of the word standard within the defined term. And he says it's for two reasons. We get the first reason at 101 and following, and then we get the second reason, that's 101, and then the second reason is 102 and following. And so that then leads to the conclusion in 110 that he's attaching no weight to the argument based on this wording. So am I wrong in understanding that all of this is about the word standard?
I'm not sure I would entirely agree with respect to 104. We see the references to we, us, our, and Northern Rock being referred to, which is language from the offer documents. At 108, we see the reference to Northern Rock, 109, Northern Rock and its successors in the signs, which I showed you in the unsecured loan document. And so at 110, I'm not sure he's confining himself, if I may respectfully say so, to the debate around only the word standard. He does deal with the word standard in this context, and he refers to that at 100. But I read the 110 as being broader. If I'm being unfair, then maybe I'm tilting it at windmills. But my position anyway is that you have to take these documents strongly into account. If I may, should we turn to the general conditions?
Well, how would you square your interpretation of the judgment with 106? Because in 106 he says consideration of this wording in the offer letter adds little or nothing to the analysis around the definition of SVR in condition 1.2. So he's plainly there not saying that he's attaching no weight. He's simply saying, well, it doesn't really seem to move the dial.
103, I mean, again, my lord, I think I don't want to get too caught up in this because my lords will form their own view of what the right answer is. But 103, the judge does refer to Mr. Lord's submission for the claimants. Referring to language which I've just shown you.
To be sure.
So I treated, and again, I don't want to get into unnecessary debate with my lord, but that's why when I read 110, I thought that the judge was dealing with all of those submissions compendiously, including the submission about the language that I have shown you.
Thank you.
General conditions, please. I'm a little concerned about the time, my lords. It's entirely my fault. But I just flag it
Yes.
for good order. I'm sorry. Now, general conditions are found in the supplemental bundle at tab 9. And I'll try and deal with this with dispatch. I'm using the 2005 version. It's the third iteration. You have before you the 2001 at tab 5 and the 2004 at tab 6. The parties are agreed as set out in the Statement of Agreed Facts that you're to work from 2001 and 2005, and indeed that 2005 and 2001 are materially similar. So I'm going to focus on this version. It's also more clearly printed as well. Now, the clause that refers to the offer letters prevailing is condition or clause 22, page 161. And as I say, my submission goes beyond mere conflict. It goes to reading the documents as a whole. What is it the borrower would have come away understanding, objectively perceived? We can return now to the front of the document. Page 155, clause 1. I referred earlier to we, us, and our in the interpretation. 1.1a, we'll see what it says there. And the judge records at paragraph 34 of the judgment that the parties agreed below that this definition has to be read pragmatically, so that the language in question can either refer to Northern Rock or to TSB as the sense may require, as it was expressed. The conditions are defined, means the conditions set out in the offer and the general conditions, so that brings in the offer, which has contractual force. Interest and interest rate are defined. We'll come back to that because there's a point there that TSB rely on. But the contractual obligation is to pay the interest rate. And the interest rate is the rate or rates of interest we charge under the offer. Hence again the primacy of that document. And it's subject, now, I note an error here in the definition of mortgage conditions. It's just a point that confirms that we've got to read these conditions in a sensible way.
Sorry, which point are you making?
The definition of mortgage conditions means the mortgage conditions entitled Northern Rock Mortgage Conditions 2001. That should, of course, be a reference to 2005. But it's just an example of not taking the conditions literally. They are not perfect.
That's not right.
I dare say if they were perfect, we wouldn't have been before the judge and we wouldn't be before my lords.
I think
then-
mortgage conditions is actually something different and it's in tab 4.
I'm sorry, I didn't hear it.
I'm sorry, my lord. I think mortgage conditions is actually referring to a different
this document
document
here.
in tab 4.
I stand corrected. I think that may be the conditions applicable effectively to the deed.
I see, yes.
Thank you. Anyway, standard variable rate then is defined at the bottom of 1.2.
And to
We've
be
got
clear,
that. Why do we need to bother with the Financial Conduct Authority's wording?
I understand the point. It's mere context. I'm not going to. I don't want to suggest. I don't want to suggest that I place heavy weight on that definition. It's
and
not the case.
to be clear, is this right? This document of itself doesn't oppose the term about paying at standard variable rate. For that, you go to the offer.
To understand what the rates to be payable contractually are and what the contractual bargain is, you have to look at the offer, because all this says is interest means interest we charge under condition 6 at the interest rate. I'll show you condition 6 in a moment. Interest rate means the rate or rates of interest we charge under the offer.
And my recollection, I haven't been back through again, is that these conditions do not themselves say you have to pay interest at the standard variable rate. That is in the offer.
Correct. And the offer doesn't say that, of course. It says Northern Rock's standard variable rate, our standard variable rate prevailing and existing. It's very important that the bargain is not that you will pay the standard variable rate. The bargain is you will pay Northern Rock standard variable rate, is described as in some places, our standard variable rate, which becomes TSB's standard variable rate under the clause I've shown you, prevailing and existing. That's the contractual bargain.
Well, just pursuing that a moment longer, the offer letters use the term standard variable rate,
They do.
and that must refer to what is defined here.
Yes, but the bargain, and to put the point differently, the bargain may be guaranteed to be below, or it may be the loyalty discount rate, for example. So the standard variable rate, yes, is a reference point, but what is it? It is our existing, prevailing, and so on and so forth, standard variable rate, where post-transfer, subject to my one qualification, our must be a reference.
So can I just explore that a moment longer? Suppose you have a bit in an offer letter that says, I can't remember all the different wordings, you will be paying at the prevailing standard variable rate. Now, the standard variable rate, capitalized, refers to what we see in condition 1. So, of itself, that standard variable rate is what we see in condition 1. Do you say that the word prevailing colours the interpretation of standard variable rate, or do you mean that even though you're to pay at the standard variable rate as defined in condition 1, that isn't the case, or what is the significance?
It must be relevant in colour, because for example, where it's described as our prevailing standard variable rate, I don't want to, maybe misdescribing, mischaracterising it, but then that has to be read together. What you can't get to in my submission is an outcome where the rate, the standard, so-called standard variable height is not prevailing at all. That would be a very odd outcome. And I place weight on the use of the words our, which you do see in all of these loan offers. That has to be referring to TSB's pre-existing standard variable rate. Otherwise,
I slightly wonder about that actually, but we'll come to that.
But otherwise, TSB can just set a new standard variable rate. Set a new one. I'll just set a new one.
I mean, just coming back to something I raised earlier, which does not on the face of it apply in the circumstances of this case. Suppose you have Northern Rock Trading and choosing to transfer part of its book, and then you look to see what standard variable rate means. It means such rate as we from time to time decide. One might think, well, Northern Rock is still trading, it's setting its rates, so that would refer to the Northern Rock rate. And then it goes on to say, if we transfer, the person to whom we make the transfer may change the rate to its own base rate. No obligation. So on the face of it, at that stage, pre the collapse, you're contemplating two different rates. One is the Northern Rock rate, 2 is the transferee's rate, and they can choose.
What you're not, first of all, you've got my submission, my lord, about why that's not been explored in this case.
Yes.
The second point is what you're not contemplating. The one thing you're not contemplating is what TSB has done. That is not provided for, it is not permissible. So if I may say so, subject to the one point that I reserve my position effectively on what would happen if you had Northern Rock in an ongoing trading in a meaningful sense.
But what about the sentence in the middle? We may change this rate from time to time under condition 7 or the offer.
Yes.
And you accept that we, after transfer, means TSB. So that's saying TSB may change the rate from time to time under condition 7.
No,
And then there's the remaining passage in that paragraph
But
which
but-
confirms that.
But the question is, what is standard variable rate there? You can't just ignore that language. So we go to this definition. Now I'll address you on this. Much means such rate as we from time to time decide to set as the base from which to calculate interest on our, look at that reference to our variable rate mortgage loans, that pack protection as it was described below. The safety for the borrower, that you're going to be treated like others, and you're going to get the market rate, disregarding the restrictions on what we can charge under condition 7. So this concept of standard variable rate is not the contractually payable rate. You can see that from the wording in brackets, disregarding the restrictions on what we can charge. It is a concept, this standard variable rate. The standard variable rate, which applies to your loan, is set out in the offer. we may change this rate from time to time under condition 7. And then you get the language of transfer. Now, let's just pause for a moment. TSB rely on the capital letter interest in the first sentence. They place significant weight on this, and they place significant weight on it below. It was a point they raised in oral submissions. You can see from which to calculate interest. Now just put to one side, put that capital letter to one side for a moment. And I would respectfully suggest that it's not the sort of thing that a typical borrower would spot, retail borrower. But if it was not there, post-transfer, this sentence would read, means such rate as we from time to time decide to set as the base from which to calculate interest on our variable rate mortgage loans. And that could only be a reference in my submission on the ordinary construction of that language, could only be a reference to TSB's own pre-existing rate. Now, and that coheres entirely with what I've said about the offer letters. It would be completely clear and we wouldn't be arguing about it. Now, TSB do rely heavily on this capital letter, and they press for effectively an algebraic approach, the approach rejected in Chartbrook, not just literalist, but they say you've got to treat this capital letter as if it's a mathematical formula. And the point they make, I'm addressing now, is that capital I interest refers back to interest we charge under condition 6. And the argument goes, which the judge accepted, that what this is referring to in this first sentence, when you're in the post-transfer world, you are referring exclusively, TSB say, to those Northern Rock mortgages that it has purchased. Because only those mortgages are subject to condition 6. They seek to delineate or reduce the scope of that first sentence by saying interest means charging under condition 6. That means it's the Northern Rock conditions. So this is a reference only to this sub-portfolio of loans.
Would you accept that interest means interest recharged under condition 6?
I will, if I may, I will come back to
Whether
that.
or not there's a capital letter. And why does it matter?
I will. Can I address that just in a moment? I appreciate it's always nice for the court to have answers immediately, but
No, please take your own
I
time.
want to just develop this a little bit, and I think you'll then see where I stand on this.
Thank you.
Now, that in my submission means, and what TSB say, we can therefore set this Whistletree SVR. It's narrow, and it's an SVR that applies just to this subcategory of people, without reference to prevailing or indeed its existing customers. In my submission, denuding the contractual language that we've seen in the offer letters of much, if not all, of its force. It's an approach that should be rejected for several reasons. First, this sentence, much like some of the language we saw in the offer letters where I made the submission, is contemplating Northern Rock as counterparty. And that language makes perfect sense when Northern Rock is the counterparty. Because of course, all of Northern Rock's loans, mortgage loans, are subject to these general conditions. So the reference to capital I interest when you're in the pre-transfer world causes no difficulties. And the submission I make is consistent with those references you see in the offer letters to Northern Rock's standard variable rate. It's contemplating a pre-transfer world. And so a reader's, even if you were the most sophisticated of retail borrowers reading this, it wouldn't cause you any particular concern. And of course, most borrowers would not be alive to these sorts of subtle points that I repeat, TSB didn't spot until the hearing, not in its skeleton at first instance, not in its pleading. I don't say they can't take the point, of course they can. But the point is it's indicative of how deeply subtle this point is. Now, where you have a transfer, you have to read this definition as a whole in a logical and pragmatic way. And you do not reverse engineer the entire exercise by reference to that capital letter. Because generally, of course, TSB's loans in general are not going to be governed by these conditions. And TSB is not in a position to vary Northern Rock's rate. Some of the loans have been transferred elsewhere. So when you then read on, that's the first sentence. The current standard variable rate which applies to your loan is set out in the offer. That confirms what this language is contemplating is the Northern Rock period. See the word current. You can't read that as being whenever you come to look at the conditions. Current means as of the day of entering into the contract. We may change this rate from time to time. That again is contemplating the pre-transfer world. And we know that because the next sentence brings in the possibility of transfer. If we transfer or dispose. This is the section of the definition that squarely contemplates the position post-transfer. And it's that rate, they may change the rate to their own base rate, which it applies to its variable rate mortgage loans. No reference to capital I interest here. It's the reverse. It's all lowercase. It's variable rate mortgage loans. That can only be a reference to its pre-existing.
Sorry, I may be misreading, but I don't see the word interest there at all.
No, you see the word rate and base
Sorry,
rate.
you made a forensic point that it wasn't capitalised I interest, but how does that help when the word interest doesn't appear in the sentence at all?
It's in my submission, it's relevant that it doesn't appear because it's not trying to constrain this to the subgroup of loans that have been made under Northern Rock conditions, which TSB has purchased. In fact, it's precisely the opposite, my lord. Base rate, which it applies to its variable rate mortgage loans. And I'll show you in paragraph 19 that paragraph 19.1 similarly contemplates the pre-transfer and post-transfer worlds. And when it contemplates the post-transfer world, my lord, you will see the word interest with lowercase I. So, my lord, as ever with the courts ahead of me, but
Where do you say there's a capital I? Sorry.
It's quite subtle. I mean, it's the very fact that my lord's asking the question, it confirms how subtle it is. But if you look immediately below the definition, the bold standard variable rate, the word interest features. And look at how hard you have to look at it. I confess I had the same experience.
I mean, just pursuing this for a moment. So interest, as you say, is defined as interest we charge under condition 6. Well, condition 6 on the face of it is concerned with mechanics.
I agree, and that's
Then it says at the interest rate. The interest rate is then defined, which is the rate charged under the offer. And the offer refers to the standard variable rate. So I wonder whether this isn't all rather circular.
No, it's not, because the offer refers to prevailing for pre-existing customers and it refers to our. And that must mean post-transfer, TSB's rate as applied broadly to its mortgage book. I appreciate they've got 2 or 3 rates, but I'll come to that. You cannot read that in any other sensible way. It cannot be referring to either, if you see the Whistletree SVR as the creation of a brand new rate, it can't be contemplating that. That would be a significant problem for any retail borrower if the transferee was allowed to do that. And it also is not contemplating taking the last rate set by Northern Rock or NRAM and then varying that. That's not our prevailing or existing standard variable rate.
And at the risk of delaying a moment longer, so if one takes simply standard variable rate, and that ties in also with clause 19, do you accept that the transferee gets a choice?
So I'm coming to this.
Yes, okay.
I'm coming.
In that case, come to it at your own time.
I will not. I'm not going to sidestep that question. I want to engage with it. Now, look at all the language from if we transfer or dispose. All of that is contemplating the post-transfer world. So when you're reading that first sentence, you have to recognize, if we're going to go on this granular approach, it is contemplating the pre-transfer world. And if I was wrong about that, my lords, all of that language after if we transfer, all of it would be completely OTOs. It would be unnecessary, and it would be entirely surplusage. Why? Because if TSB are right, and we see the same in clause 19.1, if TSB are right, they don't need any of that. They just take the last rate set, the last number, and vary it under 7.2. You don't need anything else, because they could vary it under 7.2 to bring it into line with their own base rate, their own prevailing standard variable rate, or not.
Could they? I mean, suppose that their standard variable rate were much higher. Would clause 7.2 allow them to go to that?
It may well do so, subject to the broader collection of fairness arguments which arise under the implied term, under MCOBs and the like. I'll collectively call those the fairness points. But an important point in relation to the fairness points is that they're not entitled, they're not, on TSB's case, these fairness points take centre stage. And if I'm unsuccessful in this appeal, and I submit I should be successful, then we move on to a debate about implied terms and other matters, where they take centre stage, a term not written into the contract.
And I see all this, but just in terms of the surplusage point,
Yes.
You say, well, TSB could anyway have moved their standard variable
On-
rate if they'd
on-
wanted to.
On their construction.
On their construction. Because they could have done that under 7.2. Which bit of 7.2 would have allowed them to do that, supposing their standard variable rate to be substantially higher?
Well, no doubt, and I don't know what TSB would say, but they would no doubt refer to good commercial reasons in B, or maintaining a prudent level of profitability under C. And again, subject to the fairness points, but the fairness points should not, in general, be the first port of call. And in my submission, what you're going to see, so that does provide the appropriate constraint. And when you're looking at this in the round, you have to ultimately choose, of course, between my approach and my own friends. If there was a perfect construction, I repeat, we wouldn't be here. But you have to, in my submission, adopt a construction that reflects what the bargain was intended to be. I see my Lord Justice Baker looking at the clock. When I
That's fast.
it is that I was just going to make that
It's
point.
about 5 minutes fast.
Now, what is envisaged here now, and as I say, it's a pretty surprising construction that has all of this language about if we transfer as being completely OTOs and similar language in 19.1. Because on TSB's case, you just take the previous rate and vary it, whether to bring it into line with your own standard rate or otherwise. You have to give this language effect, and our construction does so. Now, my lords have asked me about the word may. The transferee may change the rate. That allows in practice for a transitional period. I mean, this is what is contemplated in my submission. We have to work from first principles here. No disclosure, no evidence. What is contemplated is a transitional period to allow for the migration of borrowers. And what that means is you don't have to move it to your base rate, but what you're left with is the last rate set being the interest rate. The interest rate that you are charged. And what is contemplated in ordinary market conditions, where, as I've shown you, the standard variable rates are typically broadly in line because there's a market, is that you will be moved in due course. And you've got to assume that this is being concluded envisaging typical market conditions where these rates are comparable. But what you can't do is force a transferee immediately because it takes time to migrate thousands of customers across.
Now, I quite follow that this is not how the case is argued on either side and doesn't fit the facts. But even so, I'm afraid I'd like to understand how the clause might have been thought to operate when it was brought into being. So why couldn't a transferee stick with Northern Rock rates, supposing Northern Rock still to have been trading as presumably was contemplated?
My lord, I would graciously prefer not to engage because that's just not the fact pattern.
It isn't the fact pattern, but it might cast light on how this clause was meant to operate.
If one was to engage in that hypothetical, then you might be able to, and I don't accept this because but if one was to say, well, you could have tracked the Northern Rock rate, that has to be the rate that Northern Rock.
Oh, absolutely. On this scenario, the hypothesis would be the contract envisages Northern Rock still in being, but we have the right to transfer elsewhere. When we transfer elsewhere, well, the transferee can either stick with the Northern Rock rates, well, that's not unfair on the borrower, or it can move to its own variable rates. Now, if that were what was intended, that would fit this clause.
It may do so. It also, in my submission, fits my case, which is when you don't have that rate anymore, the position, and it was advanced below in this way, in the skeleton, is that you have a choice between the last rate set or moving to your own base rate. And no one would be expecting the last rate set to endure for a long period of time because, again, market conditions would typically be such that there will be changes in the market and you will wish to move to your own base rate, which, by the way, will not be dissimilar to the Northern Rock rate. And when those market changes come, you want to be able to move. So no one's expecting that you'd be sat on that rate for a very long period of time. And what it recognises, our construction, arising in unusual circumstances on the basis of imperfect language, is that there's going to be an expectation that you can't force the new lender to do it immediately. And so there's some latitude in respect to the transition. And as it's said in the skeleton, the judge described this as the developed interpretation. I don't want to spend too much time on this because then myself and my Lord Justice Arnold will end up debating exactly what the judge meant, and I'll no doubt come off the worst for the debate as ever. But the judge said it was a developed version. That's paragraph 77 of his judgment. But it wasn't. If the court in due course, and I don't propose to take you to it immediately, but it's paragraph 60 of the first instance skeleton. The reference is supplemental bundle, tab 2, pages 33 and 34. I do place reliance on how it's expressed there. And it was also pleaded in the reply as one of our cases. And for completeness, you've got it in the reply in core bundle, tab 11, page 183, and it's paragraphs 11.1.2 and 11.2.2. And I have to say, as I'd read actually the judge's characterization of our original position, it actually reflects the same thing, because he says if TSB are going to vary the rate, then they've got to move it. So we've always been clear that we countenance a position that coheres with the may. Appreciate it may not be exactly what my lord has been canvassing with me, which we haven't explored in great detail because it doesn't apply. So you have to try and work with the language to reflect the circumstances. So you can move over. You're not obliged to do it immediately. The parties are assuming normal market conditions. It's something the lender will want to do likely. And it's also very important because there's the second word may here. The person to whom we make the transfer may make further changes to that rate, last sentence of the definition. So if and when they move, that becomes the SVR, if and when the rate is moved, and they may make further changes. And that language sometimes may involve the language of possibility, but sometimes it involves the language of what you are permitted to do. And indeed, I noticed in Miss Lamb's witness statement, she refers to it as permissive. But permissive also delineates what you have permission to do. You may do this. Doesn't mean you can do everything else as well.
It's a bit odd in a way, in the sense that you've moved your standard variable rate, which may or may not be constrained by things such as you find in condition 7. But presumably on this thesis, you can't move your standard variable rate upwards, even though you move it upwards for other borrowers, if condition 7.2 isn't satisfied.
And that's the bargain that has been struck for these borrowers. But again, we don't have other mortgage contracts that TSB has, but there's no suggestion that these terms are unusual. And so one would expect to see, and again, I'm working from first principles with what I can, what I have, something similar in their terms. And they've certainly not come forward and said, oh, this is wildly different.
What do you say to the
argument against you that if your interpretation is right, it renders certain words in the conditions OTOs, including the balance of paragraph 19.1.
I respectfully disagree. I mean, the balance of 19.1 reflects the second half of the definition of standard variable rate, where we transfer any person the right to set the interest rate, and we have set the interest rate by reference to standard variable rate. That person may set the interest charge on the offer. So it's page 160. You'll see the lowercase interest to pick up my Lord Justice Arnold's observation earlier. So when we're talking about the post-transfer world, and I stress this, we are not referring to interest with a capital I by reference to that person's own. And the word may simply reflects the word may in the definition. So I don't see how that counts against me. The first sentence refers to the possibility of a transfer, and then you get into the same or language that coheres squarely with the interpretation I give to the definition, including in particular the second half of the definition. You have to read that standard variable rate definition in a coherent whole. There is no, in my submission, unless I'm missing something, and no doubt my learned friend will explain here where I've gone, but there is no dichotomy or dissonance here. And nowhere in this contract do you find any suggestion that that TSB or the transfer rate can take the last number set and vary up and down. This is a consumer contract for retail borrowers. Lord Newberger's observations. If you were expecting to see those sorts of rights being conferred, you would expect to see that spelt out, because the consequence of this is that Northern Rock could transfer to a subsidiary of its own and then have the sort of rights that TSB says it has. Very surprising in my suggestion that would be the effect and the intention of the parties. You can move it to your own subsidiary, and then they can either follow apply their own rate or have a completely different variable rate. That can't be right. And Northern Rock certainly couldn't do that. Now, it's 1:05.
Yes.
My lords, I'm broadly halfway through my entire submission, so I'm conscious I'd like to finish before the end of the day to give my learned friend a chance. I'm conscious I'd like at least a short reply tomorrow. But it need not be long. An hour is provided for entirely, that's too long. It need not be anywhere near that long, but I will keep going as quickly as I can.
Yes, and I know you've had plenty to respond to. I think you have got to finish by, I don't know, 3:45.
Thank you, my lord.
Yep, 2.
Yeah,
Let's go back to James.
Can someone pop down now? We've just broken for lunch. Oh, okay. Okay, I'll just pop out and see if they're there. All right, I'll give you a call.
Get that switch on. It just it wants the password to just switch it on.
That's fine. I think that was doing it, so I'll sort that out.
Oh, yeah.
That's what I was like. That was real time login.
Yeah.
Yeah.
Emma said that someone was coming down because I don't know. You weren't able to deal with login stuff, but she's reset it for me several times, and when I put the details in, it doesn't work.
I will try. I'll just try swap the laptop anyway, and then make sure it's on the right connection.
Yeah,
And then
I
just
think
see
it's
if
not
that
on the
works.
right internet. The right internet doesn't seem to be
Yeah,
available.
if not, then we can try log into local and then see if that works.